You're watching The Legal Breakdown. So, Glenn, we've got some major news out of Florida where Donald Trump is on trial for his illegal retention of classified documents. Judge Aileen Cannon has issued a major ruling. Can you speak about what she just did?
I can, Brian. And on the surface, it sounds like really good news. Why? Because Judge Cannon denied Donald Trump's motion to dismiss 32 felony charges against him for violating our nation's espionage laws, right? And there was much rejoicing. There should be lots of celebration when you hear something like Judge Cannon denied a motion by Donald Trump. How often does that happen? Here's the concern, Brian. You have to scratch below the surface of Judge Cannon's ruling because, what you dig up there is really pretty ugly and really pretty troubling. I wish I could bring better news to everybody. Let's start with the order itself. So after there was a pretty lengthy oral argument, it lasted the better part of a day, on whether the 32 espionage charges that have been brought against Donald Trump for him possessing what's called national defense information, some of our nation's most closely guarded secrets. He was possessing them unlawfully at Mar-a-Lago, storing them in ballrooms and bathrooms with people coming and going, having almost unfettered access to these highly classified documents. And for that, Jack Smith and the grand jury indicted him on 32 counts of espionage, violating our nation's espionage laws. Donald Trump filed a motion saying, Judge Cannon, you need to throw all of these charges out because there is something called void for vagueness. What in the world does that mean? It means that if the law that's on the books is too vague, like it says, it's against the law to possess some government documents. Well, what in the world does that mean? That's a very vague way to word a criminal statute. Donald Trump tried to claim, get this, that our espionage laws that have been on the books since 1917, that have been used countless times to prosecute some of our nation's most infamous traitors, that somehow they're just constitutionally vague and no one can make heads or tails of them. So Judge Cannon should throw out the charges that were brought under the Espionage Act. It was a laughable claim from jump. And yet, when they argued this issue for the better part of the day, before the day was even over, Judge Cannon released this order, which is about 250 words. It's basically one page. It does not cite, this will blow the minds of anybody who's ever looked at a judge's ruling. It doesn't cite a single case, no precedent, no case law, nothing. And here's what she says. She says, well, I'm going to deny Donald Trump's motion to throw out his 32 espionage charges, and I'm going to do it without prejudice. Those two words are critically important. What does that mean? When a judge decides something without prejudice, it's as if she didn't decide it at all, because without prejudice means you can raise it later, anytime you darn well please. And maybe when you do, I'll grant it. And Judge Cannon in this order actually goes on to encourage, my take, Donald Trump to raise this issue again during the trial, specifically after all the evidence has been presented and we're talking about jury instructions, because maybe at that time, I'll agree with you that these charges are somehow unconstitutional because they're void for vagueness. Here is the real problem with that. If Judge Cannon had granted this motion to dismiss yesterday, you know what Jack Smith could have done? He could have appealed it to the 11th Circuit Court of Appeals, which has twice previously reversed Judge Cannon for doing things to the extreme benefit of Donald Trump that she had no business doing. This probably would have been the third time. If she'd granted the motion, Jack Smith could have appealed it. It would have been reversed. And then Jack Smith, I think, of necessity, would have had to have moved to recuse her. And I think we would have seen the last of Judge Aileen Cannon as the presiding judge. But she's too smart for that. She said, I'm going to deny the motion so Jack Smith can't appeal anything right now, but I'm going to suggest that Donald Trump, who appointed me to my lifetime position as a federal judge, The reason I'm sitting up here wearing this black robe in this beautiful federal courtroom is because that defendant gave me this job. He's my benefactor. Now I'm going to be his. What she did was she said, I'm going to deny it now, but I'm going to urge Donald Trump to raise it later. And here are the consequences of that. If it's raised during the course of the trial itself, jeopardy has attached. What does that mean? That means if she grants the motion to dismiss after the jury has been sworn, after jeopardy has attached, well, that means the case is over, the charges are thrown out, and Jack Smith cannot appeal it. So if she is intending to do something nefarious, boy, she may have just accomplished it with the way she half-stepped this judicial decision in basically a one-page order with absolutely no case law authority supporting what she just did. Brian, if it were me, and I'm not here to give Jack Smith advice, I would take this order, I would package it up with everything else Judge Cannon has done to the extreme benefit of Donald Trump, and I would at long last file the motion to have her removed and let the courts, including the 11th Circuit Court of Appeals, sort it out. Let's put this in the harsh light of day. Let's have a hearing. Let's get a ruling, and then let's move forward. Let's not look back when she ultimately dismisses the case during the trial and Jack Smith no longer has the opportunity to appeal it. Let's not look back and say, we should have filed the motion to recuse, because then it'll be too late.
Right. And at this point, basically not wanting to disturb the beehive that is Judge Cannon, it doesn't matter because she's already proving that she's in the tank for Donald Trump anyway. So what are you accomplishing by virtue of not disturbing that beehive when the beehive is already completely hostile to you? Glenn,
the bees are swarming all over Jack Smith. He's being stung left and right, as are his prosecutors on his team. How about we file the motion to recuse and litigate it once and for all?
Can you explain how this is not appealable if she ultimately does decide to use this absurd theory that had been surfaced by the Trump team once the jury is already seated? Don't you always have the opportunity to appeal a decision by a judge in a lower court?
Yeah, you would think so. So ordinarily what happens, and I asked one of my appellate gurus about this before we hopped on today. Ordinarily, when a judge issues a ruling that is a case dispositive ruling, in other words, if a judge rules that I'm tossing out the indictment, if that ruling comes before the jury is sworn in and the case begins, then it can be appealed. But once a jury is sworn, that's when jeopardy attaches. That's a fancy way of saying anything that happens after that point, it really can't be appealed. Why? Because you're already being tried, and double jeopardy would prevent you from being tried a second time once that jury is sworn. That's why it's kind of do or die time.
Okay, now it's worth asking this again, and I know we've spoken about this on numerous occasions, but did she offer any indication as to when a trial date might actually be?
Yeah, so first of all, there is still a second motion to dismiss that's outstanding that was argued at the same time as the espionage motion. She hasn't even decided that one. That's Donald Trump's claim that the Presidential Records Act, lets him grab all the records he wants and take them from the White House and store them at Mar-a-Lago in his bathroom and his ballroom. That's not what the Presidential Records Act provides. It actually provides the exact opposite. They're not the president's records. They belong to the American people, and they must be delivered to the National Archives. But that issue was argued at the same motions hearing as the espionage motion to dismiss. She hasn't even decided that one. But, even more concerning on the trial date front, last time this case was up for a hearing before the motions hearing, she asked the parties, what's a good trial date? Jack Smith said July 8th. Donald Trump's lawyer said August 12th. She decided that those weren't, quote, realistic, and she refused to set a trial date. And that, Brian, is yet another fact that goes into the recusal bucket. I don't know that I've heard judges say, okay, what's a good trial date for the parties? And the parties recommend a trial date that's only a month or 5 weeks apart, and the judge says, no, I don't think so, and I'm not going to set a trial date. What does that do? it does nothing but delay this case. And because delay is precisely what Donald Trump does, Judge Cannon appears to be on Donald Trump's side, on Donald Trump's team. Her impartiality can reasonably be questioned. It should be questioned via a motion to recuse. So to answer your question, no trial date in sight.
All right, let's finish off with this. I know that in speaking about this stuff, it seems so obvious to us, but there's still a different bar that has to be met for removal as far as the 11th Circuit is concerned. So do you think that based on everything we know, based on her denying the motion without prejudice, based on her continued insistence on interfering on Trump's behalf, based on her offering a delay to the Trump team that they didn't even ask for in terms of the trial date, do you think that's enough to satisfy the higher bar than even you or I have just speaking about this stuff to actually have her removed from this case?
Yeah, I do, because the language of the federal law governing when a judge must remove themselves, must recuse from the case, is actually not that high. Here is the exact language in the federal statute. If a judge's impartiality might reasonably be questioned, they shall remove themselves from the case. Her impartiality is reasonably being questioned. Not that a judge can't be impartial. It's really more of an appearance thing. Well, if her impartiality might reasonably be questioned by a reasonable person, not a hyper-partisan, then she should recuse, and we should get a completely independent judge, like one who does not owe their very lifetime job as a federal judge to the defendant over whose case she's presiding. I believe the prosecutors can meet and exceed the burden set out in the federal law for recusal, and I hope to heck this most recent debacle moves the prosecutors in the direction of a motion to recuse.
Well, from your lips to Jack Smith's ears. And also, I hope this is some indication for legislators out there to maybe introduce and pass some legislation that would prevent judges from overseeing cases where the defendant is the very person who appointed them to their job. So both things to think about. With that said, we'll obviously stay on top of any updates we get in this Florida trial, as well as the rest of the prosecutions that Trump is contending with right now. So for those watching, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.